Private Prosecutions. This is from the webpage of the Ministry of Attorney General. First, I'd like to start at the top of the page so that we're always clear at what we're looking at here. This is the service corporation called Ontario. The Ministry of the Attorney General is nothing more than the legal department for that service corporation. And the Attorney General is the top man or woman who's acting in their legal department. Remember, legal doesn't apply to a man or a woman. It's no different than if the top man or woman for the legal department of Tim Hortons, Burger King, or McDonald's contacts you. Do they have any jurisdiction or standing over we the people? No. And neither do any of the agents or officers under their control. Remember, the Attorney General's this title that's been given to these people, which is also meant to be an intimidation title. Ooh, the Attorney General's contacting me. Ooh, I should be scared now. No, you shouldn't. It's just a man or a woman. And the only people that they have control over are agents and officers under their control. That's it. Or if there is a contract in which the Service Corporation Ontario has entered into that is now in breach by the other party, that's where the Attorney Generals and Crown Attorneys are supposed to step in. Unfortunately, we have all been led to believe that this man or woman acting as Attorney General, that they are the ultimate sheriff in town, and that they are the ones that are keeping our justice system intact. Well, there's a trick word for you, our. Whenever you hear the word our, who are they referring to? Our legal system, the Service Corporation Canada, or the Service Corporation Ontario, or Manitoba, Saskatchewan. Every provincial government is a corporation. So Canada's legal system, we already know the difference between legal and lawful. That's when you turn right away from this, because none of this applies to you. But you have to educate yourself to understand what this service corporation is actually providing to you. So I've underlined it. It says Canada's legal system is based on English and French systems. Oh. Then it says the country fell under English common law except for Quebec, which follows civil law. That's a point everyone in Canada needs to understand something, is that Quebec doesn't operate under common law. It operates under civil law, codes, rules, statutes. Glad I don't live there. Canada's legal system is based on a combination of common law and civil law. So the Service Corporation Canada is telling you that the system at which they've created, our legal system, it's based on a combination of common law and civil law. Well, that's great. That has nothing to do with me, and it has nothing to do with you either. The common law tradition, as it shows, is law that is not written down. Common law evolved into a system of rules based on precedent. Well, that's what this corporation evolved with the common law. They created rules based on precedent. The common law cannot be found in any code or body of legislation, but only in past decisions. Now, they play with words all the time in their communications within these websites. So, yes, it can be found in past decisions, but what they're referring to is, as it says in the next line, because judges can announce new legal doctrines or change old ones. That's right. A judge can do anything he wants in the legal world. That's got nothing to do with us because they've been given the authority, the jurisdiction and control within their society, but that does not include jurisdiction over a man or a woman. It's that simple, people. What is going on here? And all of these people that are honorably working in these capacities as Attorney Generals, they've also been lied to. That is also something we're going to address further on down the road. But at this moment, I just wanted to share with you exactly this is what they refer to when they say our legal system. So let's get back to the private prosecution. The private prosecution, if you want, take a moment and pause this and read this page. Ultimately, what it's showing you is the process in which they're doing. They're explaining to you that when you appear at the courthouse, and if you're going to lay private prosecution charges, the process is very straightforward. But ultimately, on their side of the equation, they are in control, always. Remember that. On the common law side, the man or the woman, you're holding court. You are the sovereign in this world, not the queen. You are the sovereign. You are the man or the woman accessing that public courthouse in the correct capacity. Now, I'm going to go just a little bit off topic for a moment surrounding private prosecutions because history, my fellow man, is completely ignorant on. The Norman Conquest ended the British monarchy. This was almost 1,000 years ago, and people do not understand this. Now, William the Conqueror did a very careful accounting of everything he conquered. He established a sovereign patent, and upon his death in 1087 AD, he divvied up all the land in Britain among his faithful nobles and declared them all sovereigns in their own right. And that very fact carries forth today from history, applying to every man and woman in this country. History is very important, and McGill Law Journal put out a wonderful article which I'll include in a PDF below. The general rule in England is a very simple one. Under English law, there is not the slightest doubt that a private prosecutor could on November 19, 1858, and indeed can at the present day, in the absence of intervention by the Crown, carry through all its stages a prosecution for any offence. That's very important that you understand. Further, the common law is clear. Under English law, there is not the slightest doubt that a private prosecutor can at the present day, in the absence of intervention by the Crown, which is a corporation, carry through all its stages of prosecution for any offence. And further, a private person will normally prosecute only where his interest is deeply affected or his emotion strongly aroused, and not always even then. Even in early times when passions were stronger than they are now, and the desire to retaliate was not looked upon as uncivilized, it was thought necessary to supplement the thirst for vengeance by a regular system of presentment of crime by the tithing and grand jury. A system of private prosecutions can be justified in terms of both society's interest in increased law enforcement and the individual's interest in vindication of personal grievances. Full participation by the citizen as a private prosecutor is needed to cope with the serious threat to society posed by the public prosecutor's improper action and inaction. That's very important. So we're going to do a very simple side-by-side comparison if you were to access the court today using their private prosecution service on the legal side. Ontario, again, is a Crown corporation. It is a government services corporation. They operate in a public courthouse. It's a private society, the legal society, and their courts are inferior courts. Private persons are fictions, is a legal term, and persons must follow the Crown, a corporation, process. The process on the Crown side is very straightforward. It's very similar to the common law side that we're eventually going to see here. First, you arrive at the courthouse with your paperwork, and you're going to require to see the Justice of the Peace. You will go before this Justice of the Peace, and you will be sworn under oath or affirmation. You will lay this information with the Justice of the Peace, and then at that time, he will basically decide whether he's going to proceed or not in their world. The Crown Prosecution Service is notified, and the Crown Prosecution Service also has control over your case. The accused then would be summoned, or a warrant would be put out for them to appear, and the JP has control, remember, over persons in their legal court system. The Crown Prosecutor can and does take over the majority of any cases if they're brought through their system. Most of the time, the Crown Prosecutor is staying them or dismissing them. All legal processes and options apply. The Justice of the Peace rules, and the jury is under their control if it is brought before a jury. Again, all legal processes in which the Crown Prosecution presents, that is how that court, the jurisdiction of that court, is proceeding. The Appeals Court, Supreme Court of Canada, all of those options are still available under their private prosecution side. But as for the common law side, we the people, which is a man or a woman, you're not a person, remember that, we are the creators of all governments and agents. So when we access our public courthouses, we access it in a lawful capacity. And our courts are the highest court on the land, that of common law. Man or woman living lawful, no legal persons exist in our world, and the man or the woman we control and we move our process. So there's a bit of work that we have to do to be honorable in order to understand, to move this process forward. So on the common law side, we go to the public courthouse, we require the Justice of the Peace to appear once he's available in a courtroom, we lay the information, we are sworn under oath or affirmation, under God preferably, and you do not swear on a Bible, so you're aware. The Crown prosecutors are not notified. The Crown has no standing and no jurisdiction. The wrongdoers, that's who we refer to as people who trespass against us. We do not use legal terms, ever. We do not use any legal forms. Let me stress that emphatically, that when you go to that courthouse, you do not use any of their forms, because all of their forms are in a legal capacity. And the minute that you place your name, your information on any of their forms, they are assuming and taking jurisdiction. And this is how we stop trespass on the case at the courthouse. We have to be the sovereign, which means when you show up at the courthouse, you supply your own paperwork, your own writings, and your own communications. That also includes any directions to the staff, which will ensure that your court and your claim, which is your property, will move through that public courthouse like lightning. That is the object of us accessing the public courthouses in the correct capacity. Now, when you stand before the Justice of the Peace and after you've laid your information, if that Justice of the Peace is competent, he can issue warrants or summons, depending on what the charges are that you've laid. That's what he's there for to do. After that, the wrongdoers are all brought into court and they're sworn in. The prosecutor then, which would be the man or the woman, will move their court. The wrongdoer, the man or woman, address the court as well. Trial by jury is what you require. That means that the jury decides, not the justice of the peace. And there's no appeal process and no inferior Supreme Court of Canada that is involved once that verdict has been rendered from the jury of your peers. Let's talk about judges now. There is no difference. Both of these men above are acting for a corporation. Both are a man who has duties and responsibilities, and neither man will claim another man or woman as property. Neither man above or a woman in our world can administrate property without right. That is very important and powerful to know. And finally, fact, using these people acting as a comparison, one man does trespass, and that man is liable. He has no jurisdiction over people. There is no difference with the Supreme Court of Canada. It's just a corporation, people acting as justices for the main corporation Canada. And none of these people will claim that a woman is property. Here we have McDonald's as a corporation. Here we have people acting as Ronald McDonald, with the addition of a man acting as burglar. Burglar could equate to the Attorney General's trespassing that's occurring in our world today. None of these people, your fellow man, have jurisdiction over you. Remember that.